On October 7, 2028, the Supreme Court heard arguments in a case that could reshape our understanding of free speech. The case is Chiles versus Salazar, and it's tackling one of the most complicated questions in First Amendment law. When does regulating medical treatment cross the line into regulating speech? And what happens when the speech in question involves deeply controversial subjects like sexual orientation and gender identity? The justices are considering the intricate balance between individual expression and government interests. The facts of the case are this. In 2019, Colorado passed a law banning conversion therapy for minors. That term refers to treatments aimed at changing a person's sexual orientation or gender identity. The law prohibits licensed mental health professionals from providing such therapy to anyone under 18. Kaylee Chiles, a licensed counselor and practicing Christian, challenged the law. She said she doesn't try to convert her clients, but she does work with minors who may want help reducing same-sex attraction or accepting their biological sex. She argued that the law targets her speech based on its viewpoint. Chiles sued in federal court, seeking to block the law from being enforced against her. But the district court refused to grant an injunction, and the 10th Circuit Court of Appeals upheld that ruling. Why? The lower court said that the law regulates conduct, not speech, and therefore should be reviewed under the most deferential constitutional standard, rational basis review. And under that standard, the law stood. Chiles then appealed to the Supreme Court, which agreed to hear her case. The key question is, does Colorado's ban on conversion therapy for minors violate the First Amendment by restricting a therapist's speech based on its content or viewpoint? And if so, what level of scrutiny should courts apply to laws like this? Rational basis, intermediate scrutiny, or strict scrutiny? Under current doctrine, speech by licensed professionals, especially speech that occurs within medical or therapeutic treatment, may sometimes be regulated as professional conduct. But when a law targets specific viewpoints, it may be subject to strict scrutiny, the highest level of constitutional review. This distinction, conduct versus speech, is at the heart of the case. Representing Chiles, Attorney James Campbell argued that the law discriminates against therapists based on viewpoint. It permits affirming discussions but not disapproving ones. That, he said, amounts to unconstitutional censorship. The federal government, through principal the Deputy Solicitor General Hashim Mupin, agreed. He emphasized that unlike medical procedures, Chiles therapy is based solely on speech. Therefore, it should receive full First Amendment protection. On the other side, Colorado's Solicitor General Shannon Stevenson defended the law as a narrow regulation of harmful treatment, not speech. She emphasized that the law applies to a very specific form of therapy with documented psychological risks, and that therapists are still free to express their views outside of treatment sessions. Several justices appeared sympathetic to Chiles' arguments. Justice Alito was especially concerned about ideological enforcement disguised as medical consensus. He suggested that the law might be engaging in blatant viewpoint discrimination. Justice Kavanaugh remained silent, but notably, he didn't ask a single question, leaving his views unclear. Justice Barrett seemed open to sending the case back for further fact-finding, hinting at procedural caution. Justices Sotomayor and Jackson expressed skepticism about Chiles' standing. Since Colorado hasn't enforced the law against her and claims it won't, they questioned whether there's a credible threat of prosecution. Justice Jackson also pointed out that states have long regulated medical treatments, and that it would be odd for talk therapy to receive more protection than physical treatments just because it uses words. There is a lot at stake with this case. This case isn't just about therapy. It's about the boundaries of state power, the rights of professionals, and the role of the First Amendment in therapeutic settings. If the court rules in Chiles' favor, we may see a significant expansion of constitutional protections for professional speech, potentially opening up challenges to a wide range of healthcare regulations. On the other hand, upholding the law may reinforce the principle that public health protections can include restrictions on certain forms of therapeutic practice, even if those practices involve speech. One lingering question is whether the court will decide the case on the merits, or simply remand it to the lower courts to apply strict scrutiny themselves. Justices Barrett, Sotomayor, and Jackson all seem to suggest that the lower courts should examine the law under that standard first. A decision is expected this summer. That's your quick legal lecture on Chiles versus Salazar. A case about therapy, but also about speech, identity, and the limits of government authority. It's a landmark moment for constitutional law, and we'll be tracking every development closely. What are your thoughts on this?